Welcome to the Immigration Center for Women and Children's Declaration Training, working with clients on U-Visa declarations. The basics are that this is where we tell the applicant's story to the Immigration Service. There are a couple reasons that we do this. One, that it's empowering and we need to tell her story and we show how she meets the requirements. It's also a required part of the U-Visa application. They require the victim statement. The thing about a declaration, it's not an affidavit. An affidavit has to be notarized. A declaration does not have to be notarized. But it does have to be signed, and there needs to be a line in there that says it's told under the penalty of perjury. It needs to have relevant sections to help immigration go through it, divided into short paragraphs, or it can be a narrative. We have discovered that the Immigration Service is very generous in how it accepts these. Generally chronological. It has to be credible, and we'll talk more in depth about credibility, and it must be relevant to the legal requirement that it is trying to show that it meets. Credible generally means it needs to be detailed. So if you just say, I was a victim of domestic violence, you're not giving them anything upon which to base their credibility determination. So you need to give them enough detail that they can say, oh yes, she really was there. This really is a legitimate story. And specifics. It shouldn't say, this it says here, he would always. And we've come to learn that a lot of Spanish speakers do speak in using that as their verb tense. But if you can help them, instead of saying he would always press for at least a couple of distinct episodes in which one of these, if he initially tells you he would always push me against the wall, say, okay, that's terrible. Can you tell me about one incident where that happened? And then can you tell me where one more incident? And so that you're able to provide the details. One of the things that we really impress upon applicants is that these are adjudicated. One of the great things about the U-Visa is that the person never has to appear for an interview. The only disadvantage is it means it's adjudicated on the other side of the country by someone who will never meet her. And while we'll be sitting there with her and we fall in love and we completely believe her, her words are what's going to need to convince the person in Vermont. It also needs to be consistent, and this is one of the biggest problems that I've seen in declarations, is either they are inconsistent within the actual declaration, or that they are inconsistent with other documentation, like the police report, or the therapist letter, or other restraining order declarations and things like that. So that's going to be our job to do that. And if something is in the declaration that says, I told my sister-in-law blank, generally you will want to have evidence from the sister-in-law. So they will expect that you're going to support it with other documentation if you suggest in the declaration that there is some other way of documenting that. It needs to be relevant, and in these areas of priority. Helpfulness in reporting the crime, helpfulness in explaining what happened to the police, helpfulness in any follow-up that law enforcement has asked of you, details of the criminal activity, details of substantial abuse, and eligibility for the inadmissibility waiver. So basically the requirements. Now we're going to talk about domestic violence, which is only about half of what we're doing here at ICWC, but they are usually the most challenging applications. Extremely important things to do in a domestic violence case that may not be as relevant in a felonious assault case are that it's important to demystify the process, because she's already feeling like a victim. And so when something is mystical and obscure, that just confirms and makes her feel lost and helpless again. So it's very important to make her a partner in the process and explain each of the steps rather than simply saying, have you ever been arrested? You explain why why that would be relevant. Avoid retrauma, and we'll talk about some techniques for avoiding retrauma. You had to explain to her why each of the aspects is relevant. We have to get into detail and explain to her that, and also explain to her what the context, as I said, of each of the questions is. For demystification, it's really, we want her to feel like she's in control of the interview. So it helps a lot for you to be facing her. And so using a laptop can be helpful, or taking notes by hand. I have actually asked applicants how they feel about me turning away to work at the computer, and they have invariably said yes. But then I will also work hard to make eye contact at the times when we're sort of more in a background sort of phase. It's ideal if you can bring your keyboard around somehow so that you're doing both. And setting up your office in advance to be able to do that is very valuable. The way Katie is right now with this very short table, it's really kind of ideal because she can be interviewing the person at the same time being able to type in there. Let her know why you're asking each question. I already mentioned this in the demystification. Explaining the legal requirements at the beginning is very valuable, and that the declaration is going to be identifying how she meets each of those requirements. Explain, and this is very valuable, and we're working now on a video that explains what the declaration is all about. We had one, but it needs work. And if we tell her that this is different than a divorce, and it's different than a restraining order application, that those kind of declarations are getting at something completely different. Especially with the divorce, you're explaining why it's his fault rather than yours. And so we want to make clear here that you are, and we'll say this later, this is the opposite of the demystifying and the empowering, that in this case she's the victim. We aren't saying this is a fight between you and he, and you don't have to anticipate that he gets a chance to answer it. That's something very important for people to know. He will never see this. He will never have an opportunity to fight. So sometimes you'll find that somebody's being defensive, or that they're giving you a story that you don't understand why it's not just coming out straight. And it can often be because they're anticipating a judge listening to his story first and challenging her, or that she's arguing with him for custody. So it's not either of those kind of formats. And we will be putting that in the video. Assure her that although we do the declaration in one session, both to minimize the trauma to you guys and to her, and also because we've discovered that by having a lot of very specific questions, we can get through in one session, so it's quicker for her and for us. We will be having another appointment after the declaration appointment. It's our second appointment. The first is intake, the second is declaration, and the third is our finalization appointment. So if she remembers details, you can make the changes to the declaration in the third, changes or additions in the third one. So suggest that if she remembers if she remembers something she wishes she had said in her declaration, she should jot it down and bring it with her to her next appointment. So this is all part of her being the partner with you in the process, rather than being sort of a passive person that you're extracting a story from. The avoiding re-trauma, what I have come to learn from various therapists is that everybody who has survived trauma knows how to deal with trauma. They know their own way. They know, I need to talk to a friend. I need to take a break. I need a drink of water. This is what I do to cope with trauma. And most people are able to just keep their experiences in the level of being upset rather than actually re-traumatized. What you should do is talk with her about what do you do to avoid trauma. So when you feel trauma coming on, what is it that you normally do, and how do you want me to serve you in that way? Whether it is to stop the declaration there and come back another time, or call somebody, or most people want to continue. But one of the really important tools that you have is that you have so much mindless stuff to do with her. You know, you've got all the forms, you've got all the, for our intake, all the sort of ministerial stuff in that. You can just take a break from the declaration and fill out forms, or take a payment or something like that. That's often been my lifeline when somebody's getting upset. We do declarations in a private office, or else behind our super heavy screens if we can't possibly get a private office. If it's going to be domestic violence or a sexual assault one, we do give that one a totally private office with a closing door, so that she knows that that everything she says is private. Tell her that we will stop at 2 hours and that we will even give her a warning at 10 minutes, like a therapist, that we are getting on 2 hours. And so she shouldn't feel like this is going to be a really horrible, long, laborious process. Tell her that, yes, we already said this, that it's upsetting, so we want her to be in control. And so that when she wants it to stop, it will stop. And sometimes it's right when you're getting what you want is right when she says, no, I can't do it anymore. Also, frequently, you will go for an hour and 45 minutes, and you haven't gotten anything super useful, the detail that you were asking for. Where were you in the house? You know, what specific words did he say? Did he shove you or did he pinch you? She has spent an hour and 45 minutes being vague and say he would always. And so at an hour and 45, suddenly she starts, with the details starting to pour out. You still have to stop it at 2 hours because it will exhaust her and it will exhaust you. And so you can always finish the declaration at the third appointment if you need to. Start and end the interview. In addition to using the mundane matters like the I-192 addresses for the last 5 years, in addition to using those as fallbacks if things start to get too traumatic, then you can do those at the beginning of the interview and at the end. Always start and end with something mundane. The details, explain to her, as we already said, that details are extremely important because the USCIS officer can never see her in person. Ask her concrete questions to get more detail when there are opportunities to do so. And if you need to make a little note in your either in what the declaration that you're typing up or anything, say, go back to this, you can do that. It's challenging. Just the whole art of doing a declaration is very challenging. And we are not going to do as we used to do at ISLA. Claudia made the most magnificent declarations by recording the video and recording the audio discussion that they had and then going back and making it super detailed and perfect. And we have learned that they don't need to be that perfect. A declaration can be a B. It can be a good, solid 80% job. And that the risk of traumatizing and dragging somebody through it all versus not getting every single little thing is definitely a worthwhile trade-off. So for describing the abuse, once again, opposite of the whole empowering thing, U visas are for victims. And people will often say, I fought back. There was a person who said, I went to, I knew that there were groceries with a bottle of rubbing alcohol, and I grabbed the rubbing alcohol, and I was going to try to throw it in his eyes when he grabbed it from me and spilled it on me. And I thought, he grabbed it from you and spilled it on you. That was the crime. The whole lead up to it was not what the crime was. The crime was what he did to you. So, and so it often people will say, we argued. That again is not the important aspect. He was arrested for having done something abusive, and that may have included him yelling at you also, if that helps put it in context. It also, yes, as this says here, we were struggling, we were fighting, and I hit him and he hit me. Okay. Point already made. All right. For the next aspect of the context that all this is taking place in, that we need to explain to our clients, for describing the helpfulness, it is for people who help law enforcement. And we'll talk more in depth about how to go into that part of the declaration. But we want an active tone rather than I made the report I was supposed to make. Instead, I reported this to police. I called the police and I reported it. I told them that, not they asked me and I said something like that. And so I reported it. Sounds more active than I made a report. So just think of that in terms, as you're going through, of putting it in active terms rather than passive terms. So again, the chronological narrative is terrific, and contrary to what I said earlier, it doesn't have to be in sections. It doesn't even have to be in paragraphs. It can just be a long story that the client tells you. And you don't need to do the summary paragraphs in bold, although it's useful for your supervising attorney when we review it. to know, oh, here's the main statement of the case, but it's not required, and it's whatever works for you with the client as you're going through it. It only needs to be 2 to 4 pages. In fact, some of our felonious assault declarations are a page and a third or something like that. So a VAWA application that some of us may have done before, or a T visa, they're going to have incredibly long declarations about the entire relationship. This is really just about the crime, what the crime was, how she suffered substantial abuse, and how she's helpful. And so if there's substantial injuries and no lack of helpfulness, it's going to be super short. It's only when you need to be more like a VAWA application that it's going to get a little longer and to give all that context. So now we're going to go individually through the requirements. You start with the police report. You already got it at the intake interview, so you've already had a chance to go over it with her and find out whether there are mistakes in it. And you can pre-draft the declaration. And one of the things that new volunteers and new staff have enjoyed in the past is to have a meeting with another new person when they're about to do a declaration and say, and have each of you read the police report and just have a quick meeting about what would you ask her, how would you frame this. It is a great way to learn from each other. And since the people who've already been here for a long time, we're jaded. We don't have your innovative ideas and your fresh approaches to how to approach the police report and the whole approach to the declaration. So I really encourage you guys to ask each other and make these play dates for framing your declarations. So the accurate parts of the police report can be totally fantastic. The great thing about waiting for the second appointment and already having the police report in hand is that you will have already found out what's accurate and what's inaccurate. You won't waste a bunch of time writing something that's wrong. And then you want to describe the crime super briefly. A sentence, a half a sentence about what led up to the crime, just to give the adjudicator some kind of context. And then here's where you're going to start getting specific. Give at least 2 details about each aspect, including where was it? Where did it start? Did things move into another place? It started in the kitchen, then it moved into the living room. Where were the perpetrator and victim in relationship to each other? So did he push her against the wall? Did he push her against a table? These are the kind of details that make it becomes a movie in the head of the person who's adjudicating it. And then what exactly did the perpetrator say? This is often the most difficult thing. He swore at me, or he was always yelling at me. See if you can help her identify at least one word that he said in these cases. And then specifically, how did he assault and injure her? And as you saw that you have in your packet, the white sheet is, and these are only in color because this is recycled paper, but the white one has the description of physical abuse that can sometimes help you ask her specifically. Did he choke you? Did he pull your hair? Did he shove you? Did he trip you? These are things that might not necessarily jump into her mind, but if you're having a hard time with her describing her physical abuse, go down this list. A lot of times people will say, no, I never was subjected to physical violence, and then you'll be talking along and you'll come to one of those and you'll say, oh, well, he choked me. I meant that he didn't punch me. So that's not an unusual way for people to observe, to think of the abuse that they've been through. So now we're into the major section of the U visa, which is helpfulness. So in the big, long outline that I gave you, the declarations for, instruction for the U visa declaration English, it's built around domestic violence, but then we also have them document just on helpfulness that you can use for your other kinds of crime. And it asks a zillion questions about who called the police, how long were you on the phone with 911, and it could be, if the helpfulness is incredibly strong, like they testified in trial, you don't need to go into all the details of what happened with the police. What I like to have is at least 2 paragraphs, I mean, not 2 long paragraphs, 2 short paragraphs or 1 long paragraph about helpfulness. So if all she did was call the police, we want to fill in and give enough detail about what exactly those interactions were like. You won't need to do that, though, if she has 2 paragraphs that go from the initial report all the way through the testifying and him being found guilty. But in that super detailed outline, we have the kind of questions that you may want to ask if you don't already know that she's got a really strong helpfulness history. Interactions with the police at the scene. We often say how many officers were there, what genders were they, did they speak Spanish. These are just the things that bring it to life. What was said about wanting the perpetrator arrested or charged, it's different in every department and with every officer. Some of them say, do you want to bring charges, even though it's not the applicant who brings charges. At least in California, it is the district attorney who brings charges. And so sometimes we'll even have police reports that say she didn't want to bring charges. And that is a mistake of the law, and that is one of the most common things that someone will misunderstand. The cop will say, do you want to bring charges in court? And she'll think that means getting a restraining order, it means having to be her own attorney, confronting him. And so misunderstanding that, she may say no. And we will have already figured this out in the intake interview, whether these are things that can be overcome or not. But this is very good detail for the Vermont Service Center to find out about whether they asked her if she wanted charges brought or not, or when they've been arrested. And frequently they don't. And I'll be talking in just a minute about that there are no right answers, but that'll be in a minute. And then I say corrections in the police report if needed, and we'll go into that in just a minute. And then any kind of follow-up. And now we're going to dive into detail. So this is on our preguntas iniciales, too, our initial questions that when we ask somebody about the crime that they were a victim of. There are a bunch of questions on our preguntas iniciales form, like, well, did you change your phone number afterward? And did the police ever call you back? We want to clarify with you, and then you can clarify with her, that there is no right answer. It's just that we are asking those questions to find out if maybe she didn't help at some point, so that perhaps she was helpful when the police were called, but then, later on, she chose not to be helpful anymore. That's why we ask the questions, but hopefully by the time it gets to the declaration stage, we've already determined that the helpfulness was sufficient. Still, there are going to be questions on this interview form that you'll ask, and she may get worried, and she may think, no, I didn't do that. She needs to know from the very beginning that it's okay that she didn't. We've already determined she's eligible. But we do want to know these things. We want to go as far as we can in the declaration saying as much as she did do. The only matter is that she wasn't unhelpful, positively unhelpful. So then we'll talk a little bit about, as I already talked about this, how the police got involved. And I'm going to show you where in our documents folder we can find this. So you'll go into the shared drive, and you see that U-visas are the top thing when you go into the shared drive. And when you go into U-visas, you go to U-visa practice materials, and the reason there's an exclamation mark is just so it shows up first. And then you can scroll down to, there's 2 different things that help us with the declaration appointment. One is the declaration appointment itself, and then model declarations. And you can look at felonious assault helpfulness questions, but it's really for all of them. And these are the questions that are just about helpfulness. So you can see how many things that you can ask and suggestions for how to phrase it. So those are also in your super detailed domestic violence one, but if you just want to talk about the if you only want to talk about how you interact with the police, that's where all those long police things are, is in the U-visa practice materials, 5, declaration appointment, and then the list of police questions. And, you know, what did the operator say? How long did it take for them to arrive, etc. And then answering when you're talking to the police officer about what happened. All this level of detail can really help if you, especially if you don't have other kinds of detail. And again, these are not only here, but they're in those instructions in the declaration appointment document in that declaration appointment folder. Did you want the perpetrator arrested? How did they ask? What did you think they meant? And what did you say exactly? if there's problems with helpfulness in the report, we can address that in the declaration, but not in a way that sounds defensive. So this is always sort of an art where you want to say, so that often the report will say something like that it was at 2 in the morning when really it was at 4 in the morning. And you want to say, I don't know why they said it was at 2 in the morning, but it really was at 2 in the morning. That's a fairly non-material difference. But you will find sometimes police reports do just get something wrong. And it's okay for her to correct that if it's an important part of her declaration. And it could be that it doesn't have to go in the declaration and it wasn't material to any of this at all. But if it is, it's important for her to address that there was an inconsistency and why she thinks there was an inconsistency without appearing defensive. So this is an art, and this is something that you need to talk with me about and talk with each other about how to frame it so that it sounds okay. For example, the officer seemed more focused on what was happening with my kids, so that makes the officer look really sympathetic, and so didn't write down everything that I said. We often actually find this with felonious assaults, where the applicant will say, I was punched, and the police report does not say I was punched, but I really was punched, and I can give you declarations from my neighbors who were there and who could see that it was. And you won't need to do that, but you can address. They didn't say I was punched, but I really was punched. I don't know why they didn't put it. They seemed focused on, on the other victims or something like that. So then follow-up after that initial interaction with law enforcement. We really want to know, because this is the key, again, of the U visa application. Was the perpetrator arrested? Was the perpetrator jailed? How long was he in jail? Were charges brought, which is done by the district attorney, not by the applicant herself? Did you get a subpoena to have to testify? And were you contacted by the district attorney's office? Was there a victim advocate assigned to you? Who was that victim advocate? Again, all these questions are in detail in that domestic violence outline. And then what happened? One of the most important things we can ask is, and then what happened? And then there's all this sort of victim self-protection. So basically restraining orders, moving, things like that. So did you get an emergency protective order? That's something that police give somebody that's good for 3 days, and it gives them time to go and apply for a temporary restraining order. And then they get a temporary restraining order that protects them while they're getting a restraining order after hearing. Often the restraining order after hearing is the most traumatic thing somebody has to go through, because she does have to face her abuser in court, and he is going to lie, and she's going to feel totally helpless, and often she's unrepresented in that. And that's why from the very start, when we even show somebody the video when they first come in for their first appointment, we say, you are never going to have to go through that. So, I've said that many times. I must feel traumatized by that. And so did the police department ask if there's anything that they could do to help, and did you follow up? Did you get a restraining order after hearing? And then was the restraining order ever violated? Now, sometimes the abuser comes back, even though there's a restraining order. And one of the things district attorneys and police say is the victim herself cannot violate the restraining order. Only the perpetrator can. And so sometimes people are afraid of that. They think, oh my God, I let him back in, I'm violating the law, I'm going to be in trouble, but that's not true. You're not going to be in trouble. And so we may not want to include this in the declaration, but I do want to know, if you let him back, why did you let him back? And frequently, it is part of the cycle of violence that we'll talk about when we start talking about emotional abuse, that she gets a restraining order, and then he says, please, baby, please, baby, please, baby, baby, baby. And she does let him back, and then there's another violent incident, and then she calls the police to report the restraining order violation. And that is all completely legitimate, and the officials from the Vermont Service Center Crime Victim Unit were in San Francisco last year, and somebody specifically said, what if she gets a U visa and then he moves back in? And they said, we are not here to determine what she does in her life. We're here to determine that she was a victim of crime and that she was helpful and that law enforcement considered her helpful. So we want to collect this information. On the other hand, there can be cases where she is not really cooperating with police. And I've had cases actually where somebody just continually, he's never there when she calls police. And when he is there, then she doesn't want to press charges. That's another thing that we say at the very beginning when we do preguntas iniciales and somebody isn't helpful. It's great that people understand what their own boundaries are, and that they say, I don't want him charged. The risk of my kids losing their father or of me losing his financial support is too great, so I don't want to bring charges. I want to reconcile with him. Even though she might be in more danger, as far as we're concerned, only she knows the right thing to do. She's doing something for her safety and security and for her kids' safety and security. And so although we may tell her that she's not eligible for the U visa, it's essential that she not feel blamed by us and that she know that she made the right decision given her circumstances. Of course, we won't have reached the declaration at that point. But there are a lot of really good reasons for not going forward with the case. So yes, this is just sort of more of the same thing. Did you call the police if you had a restraining order and he violated it? And yes, already talked about that. So with the substantial abuse, this is not the time to be stoic, and it's generally with, I mean, at the very end, I'm going to talk about clients that we have most trouble with, and stoic is definitely one of the things. People will just, they have learned to deal with the abuse. Maybe they had, maybe they're just extremely strong people emotionally, and they don't, and everything just goes off their back. But we really need to know a lot of details. So that is one of the reasons, again, that we have this little 2-page physical abuse questionnaire, because shoving can be as important as any other kind of physical abuse. So we want to know anything like that. But there's also we're going to be looking into emotional harm a lot. And this is going to be extremely difficult for people to try to put how you've been emotionally abused and how you felt is exceptionally difficult. And I'm going to direct you, are we here yet? Before we go and look at all our little charts, I'm just going to point out that for this, the strongest elements are going to be physical abuse and or threats. And when you're talking about emotional cruelty, what immigration wants to know, and I'll talk about what they don't want to know in just a second, they want to know the degree to which the emotional abuse was used to dominate and humiliate and control the survivor. And we also need to show how she was dominated and controlled and humiliated. So we'll talk more in detail about how to make that all happen. What doesn't work as well, and this is something we really need to explain to our clients when they are starting to get off on these tangents, is if he abandons her, that is not considered substantial abuse. His drug use, unless it ends up with one of these dominate, humiliate, control things. Inattentiveness, emotional or financial stinginess, infidelity, he's a jerk, he's mean to her mom. Those are things that may also have an impact on these other pieces of control, humiliation, and domination, but not in and of themselves. Those are not things you're going to want to dwell on so much in the declaration. So we like often to be able to talk, and we have this in English also, Shani. It really helps somebody, and often somebody doesn't know that they're a survivor of domestic violence until they see this amazing wheel, that it's the cycle of abuse. Often somebody will just think, every so often, he's cranky and he's extremely cruel when he's cranky. But then he's so nice. So that's the real him. The really nice him is the real him. And what happens, I did something stupid, and I brought this on. And my job as a wife should have been to avoid making him angry. And all of us do this. We've done this with our parents. We've done this with our boyfriends. We go out of our ways to avoid making them cranky when we know they're going to be cranky. Take that, quintuple that, and you've started to get into the area that our clients are going through. But often that they will think that the honeymoon, so there's always this rising of attention when he's getting irritated at everything. And then there's an explosion. Most of our survivors think that only the explosion is the domestic violence. And then there's flowers and how much he loves her, how she's the most important person in the world, and then he starts getting irritated again. Once she sees that the entire cycle of violence is the domestic violence, I've actually had clients who get pretty upset when they find that. And they feel like they've been really stupid for a long time. And they say, oh, now I see what my cousin was talking about, and saying how bad he was. That all of this whole pattern was part of that. And so this may be a really emotional thing to roll out for some clients. And you may need at that point to put all these things into effect. Maybe you should stop now, and she should call a therapist. Maybe she should call a family member. And you can certainly be sympathetic and loving. But one thing that we need to tell our clients is that not only are we not therapists, but if we tried to be a therapist, we'd be lousy at it. You know, like a therapist trying to be a lawyer, that would be malpractice. And for us to try to be a therapist would be malpractice. But this, I've just found that there's been a lot of trauma released or upset released by having people see this for the first time. But it's great for us getting those details that we want. This is also this VAWA-specific power and control wheel, and I don't know why it's in a wheel, except that is what it's always traditionally been in the domestic violence service fields. So, and Sarah Roselle made this for us. So I always think that it's valuable to have an intent at the center to be able to prove that he really was trying to do those things, rather than he's just an irritable jerk with everybody. I don't know that immigration will insist on that, but it certainly is an exceptionally useful framework for explaining domestic violence. So there is financial control and a bunch of things that are almost impossible to see here. Verbal abuse, control, intimidation, power over the children, sexual abuse, control over the immigration process, and something up there at the top that I can't read. Each of those things is certainly relevant, but only the degree to which he's intending to control, dominate, humiliate her. And you go through toward the outside how she actually is affected by those things, how she feels controlled, how she feels dominated, how she feels humiliated. So this can be useful also for talking with her. So that was the domestic violence part, but we'll talk a little more when we're talking about how to work with challenging clients. And now we're going to talk about sexual assault and how to do a declaration for sexual assault. You will describe the crime like a DV crime. This is what happened. Except, and I've included here a model sexual assault declaration for you. We want to make clear with our sexual assault survivors that they don't have to tell the story of the crime. And so you can just say, it happened. So-and-so raped me. Or I was raped, outside of a bar. Or, just the very shortest thing. And you can take that directly from the police report. So she can know from the start she's never going to have to revisit the crime ever again. And then, though, we go into more detail and helpfulness. And if she's in a position to want to talk about substantial abuse, you can talk about it. It's obviously not going to be the same substantial abuse as for domestic violence, for the humiliation, control, and domination, although the humiliation will certainly be part of it. But the degree to which she doesn't want to talk about the substantial abuse, she should not have to do that either. And here's the truly wonderful and important thing to know. Our Los Angeles office submits extremely brief sexual assault declarations, and they have all been approved. And so we will include a therapist letter, and that's where most of the story will get told. We're just going to be focusing on the helpfulness and whatever she wants to say about substantial abuse. So we're going to tell people that from the very first minute that we do an intake, that they aren't going to have to revisit all of this. And what we used to do, and we have some sexual assault counselors who love to write the client's declaration, and then we get the level of detail that the sexual assault counselor wants to get with the person, and that's terrific. But we have learned that it's not unbelievably necessary. So the hardships and equities we'll be talking about in just a minute will be the same as with any of these declarations. For felonious assaults, you describe the crime, just like you would, like we already discussed with the DV crime, where it happened, how it happened, and all that sort of stuff. For describing the helpfulness, it's where the perpetrator was identified. Obviously, helpfulness is going to be easier where the perpetrator was identified and caught and prosecuted. It's going to be more difficult when they weren't even identified. Sometimes somebody is is unconscious. I mean, they are stabbed and they are unconscious and they don't even know who stabbed them. That doesn't mean they're not eligible for the non-immigrant status, so long as law enforcement says the person was helpful enough for us. That's going to be sufficient, but they aren't going to have a lot to say in their declaration. And once again, we do want to give the Vermont Service Center something to be able to rely on in this declaration. So we'll talk about that a little bit more. And then the substantial abuse, in that case, though, is going to be piece of cake, right? So our felonious assault cases fall into two general categories, or 70% of them are either that there was some really intense physical harm, but the perpetrator was not arrested, or that there was something where the abuse wasn't as substantial, but where the perpetrator was arrested. And when we get the ones where there was substantial, like where somebody was stabbed and the person was convicted, those we live for those. Those are the easiest declarations in the world. Just say "see attached." So in the cases where the perpetrator was identified, you do it just like within the domestic violence. Like, who called the police? What did the police ask? What did you answer? What was the follow-up like? And what ultimately happened to the perpetrator? Were they convicted? Etc. And sometimes they don't know. And again, this goes back to there are no wrong answers. A lot of times, just because of police resources, that's very important. I should have mentioned this earlier. Police don't investigate every crime that they have a lead for. They don't have the resources to do it. And sometimes that's really frustrating to the crime victims. And similarly, even if a case has been investigated by the police department, the district attorney doesn't have the resources to charge every crime. So I know that the Alameda County District Attorney Domestic Violence charging official, they use a lethality analysis. They prioritize the crimes where the victim might actually get killed in a later incident. And then they go down the line from there. And that's an incredibly important analysis, and it's a triage. But it means that some of the cases that you wonder, gee, why didn't this get charged? It's because maybe that he had already been deported out of the country or something like that. So if the perpetrator wasn't identified, you're going to want to, again, write however it was that they were helpful. So did you talk to the police about whether there was gang activity in the area, whether it's generally an unsafe neighborhood, whether you know other people have had threats against them? Anything that can help law enforcement be able to have leads to be able to solve the crime, we want to go ahead and list in this. And their own non-involvement in a gang is often what police want to know. That's the most important thing, is were you in a gang? And when you say no, they know it's not gang-related, and it's extremely helpful to law enforcement. And then we always really want specifics, including what we don't want to say is, I told everybody to call the police. Instead, we want to say, so I talked to my friend Jeff, and I told him, this is what happened to me. And Jeff said, oh, that happened to somebody last week. And then I told Jeff, can you call this detective about it? So we want that level of detail in those. Okay, so that's it for helpfulness. And now we're moving on to the inadmissibility waiver request. We used to do separate declarations for the I-192 and attach it to the I-192, but as long as we have this declaration open and we're working on it, we're just going to put it in here. So we generally only need almost nothing if all they ever did was one entry without inspection. In fact, immigration has told us they don't need any documentary evidence. They only need the form and a fee waiver if it's only one entry without inspection. But we usually do a little something like say, please pardon my unlawful entry. I am a good person and I need to be protected by law enforcement. And I send money home to my parents, and I wouldn't be able to do that anymore if I had to leave. So the factors that we put in here, that we'll have in there, is the need for law enforcement. It's often nice if the person, so often you will find somebody spontaneously say, boy, was I grateful. They treated me so well and I felt like I was listened to. Sometimes they won't say that, but in those cases, put that in this declaration. I love for Vermont to know when victim and police relationships go well so that they feel happy about their jobs. The need for any victim services that the person is still getting that wouldn't be available in their home country. And good moral character, and we have a whole worksheet that we gave you. and hardships to yourself or your family members if you had to do it. I'm going to go into a little more depth in the second two. Do you need a signature? So the good moral character factors are, that somebody's a good parent, that is if they have children, and that they are a good worker, that they're proud of their job. And again, we have worksheets that can help go through this with them. And that if they are members of a religious institution, what they do in that religious institution. And that they support family members, they have a large household that they need to support or something like that. That's important to point out, that they volunteer, that they help in their church, they help in their kids' school, and if they helped law enforcement and they learned it was not as bad as I thought, I didn't get deported, and yes, I would definitely do that again, that's nice to say. Since derivative beneficiaries also have to do an I-192, they may have to do their own declaration if they have more than just one entry without inspection. They're not going to be able to be as strong as saying, I was helpful to law enforcement on this occasion, and I will be again. But they may have helped the victims in the recovery process or taking them to their appointments with law enforcement and things like that. So that's the good moral character aspects. With hardship, one of the things you can do, this is from much more intense hardship kind of declarations, and this comes from like cancellation of removal kinds of cases. They can say in the alternative what would happen if they stayed in the United States, or no, if they couldn't stay, would their U.S. citizens' kids have to come with them to El Salvador, and what would be their own hardship if that were the case? Because they're not going to be able to support those kids. They're going to feel bad that they tried to make a life for their kids in the United States and now they failed in doing that. Or in the alternative, their kids stay here and they go to El Salvador and can't support them. So those are things that you can explore with them. And again, these are only going to be in cases where you have a fairly substantial inadmissibility factor to overcome. So you don't have to torture people with the idea of losing their children to deportation by having to leave the country. For one thing, they are not going to have to leave the country. But immigration, thoughtfully, when they talk about discussing hardship in other U visa categories like the I-929 that we'll train you on later, they say you can act as though if you don't get the U visa, you'll have to leave the United States. So all of these, here's what my life would be like if I couldn't get the U visa and had to leave, are absolutely legitimate to go through. So with domestic violence cases, if the perpetrator has been deported, that's slam bang. That's going to definitely win your case for you. And so any of the living conditions and things like that. Again, with discussing hardships to family members, consider whether they'd be coming with you or not. So now let's talk about challenging clients. The ones that I have been challenged by are stoic. They are simply super strong, or they don't want to talk about it. They are not going to talk about the details of their substantial abuse. Clients who come in the door and you don't even get your first question out before 10 minutes before the end of the 2 hours. Super needy clients, that's definitely a large proportion of clients are people who really want to tell their story and need for you to tell them what to do as a result. And again, we're not a domestic violence resource agency, and we're not a therapist. We're not good with those things. And people who are evasive. Sometimes when you're trying to get the details, things just seem to become ephemeral all of a sudden, and you're not getting into what's going on. So the best resource is to, when you're feeling challenged, to just talk to somebody about it, and somebody might have either a fresh new idea about how to deal with it, or a hardened old way of dealing with it. But our generally useful ideas are, as we talked about before, pre-draft the declaration, and that way you know specifically what you still need to know. Because my experience is that asking people very specific questions that require short answers is the easiest way to get out of to get as much information as you need out of your declaration in the limited time that you have to do it. And it also keeps it from going off into areas that are both traumatic for the client and that you don't have the expertise to help with, and are not relevant. Because once again, we need to be sure that things are only relevant to them. And so hearing a lot about his, what a jerk he is to the neighbors, that is so important for her own, for you to know that she's credible, that he's like this with everybody, but immigration doesn't need to know that. And it's going to be important in divorce, if he's contesting it and she wants to say, no, I really am right about this, just ask the neighbors. Those are important, but it's not going to be important here. And so the more I've gotten into sort of short answer questions rather than sitting back and saying, tell me what happened to you. So again, we start with a police report, and then you think, what do I still need to know? And then you ask those as short questions. And the other thing is setting expectations of what we're going to be doing with the declaration. From the very start is extremely important. That this isn't a therapy session, and I say that in a loving way. I want people to be able to get the therapy that they deserve, rather than something from a lawyer who's distracted and working on their forms and working on their waivers and things like that. We're not going to be good at that. So explain what we're trying to do is show how you meet these requirements. And I'm an expert in showing how to meet those requirements, and so I'm going to ask you very specific questions about how that's done. Well, I already said everything that's on this slide. So the materials that we have on the server, I have already sort of shown you a little bit. I'm going to escape out of this and go back into the server. And I've handed some out to you already. And they are, as I showed you before, when you go into the shared drive and go into U-Visas and go into the U-Visa practice materials, you've probably, I don't know if you've perused this before, but we have stuff on the screening and getting police reports, and you guys, all the documents that you use for your first appointment are here in number 3, right in the supplement B is number 4, and then the general stuff on the declaration appointment is in number 5. And we have all of our instructions with all our questions in the main part, and then there's a whole folder on showing emotional abuse. And in this, I have a list of all the, a whole bunch of different tests that therapists use, like the Beck Depression Inventory and things like that, that can kind of help get at what the impact was on her of these things. So again, we're not therapists. We can't help her with these things, but we can at least help her identify them. So those are all in that little section there. And then also I have my materials that I've given you already, the emotional abuse questionnaire. And let's actually just talk about that for a second, because it's it takes a certain amount of finesse to use it. You guys do have that in your packet, right? I think. Oh yeah, it's in Spanish. Sorry. Yes, were you subjected to extreme cruelty? So these are only in cases where you've got somebody who's really stoic or isn't being able to get in touch with it. And as you can see, Shani, it's here in English. So we're asking them things like, have you seen the power and control wheel? Have you seen the cycle of abuse? And what does it bring up for you in terms of what's happened? And then did he get angry? How often? What words has he used with you? And if you guys come up with any new words, let's add them to this list, because this is usually the hardest. She always says, he called me names. And I can never get specifics on that. Sometimes it's wetback, sometimes it's illegal, sometimes it's bitch. But a wider range of words from the clients would be useful. So then, these are all kind of guided questions. And then questions, one of the things that we often find, I'd rather not ask about whether he has made her have sex when she doesn't want it, but when you're not able to find anything else, almost all the abusers are sexually abusive. And so even though this is extremely painful, if you can do these as super short answers so that it doesn't bring up too much trauma, you can at least broach this. You might want to tell her that it's going to be traumatic. And so now, she might want to seek other help about talking about it first. So then how did you feel, etc. So I'm getting to the part that's really hard. Okay, so one night my daughter and I went searching on the internet for words that we have felt when we have felt really trashed. And so we put them all here. And sometimes this is a much easier way for people to be able to express how they feel. because the words aren't coming to them quickly, and we have them both in Spanish and English. This can be pretty traumatic in itself to say, oh, am I supposed to feel degenerate? I didn't actually feel that way, but now, on reflection, I do. So we'd rather go through these, have you ask the questions, and start with the ones that are less loaded. And then if you aren't getting the answers there, to get into the ones that are more loaded. Or sometimes I've had people take this with them to their therapist for their therapy appointment and say, can we work on this together? And that's been very effective. It also helps the therapist when the therapist wants to, for one, give therapy, and two, be able to write a letter, because I'm sure that therapists have as much trouble as we do breaking through the stoic or the evasive or the verbose patient in their cases. So these are just some things that can possibly be useful in these circumstances. Other things that are here in this here section are we have a list of therapists, and you guys already know that we send people to a couple people we just know do a great job both with therapy and with the letters, where they actually do the inventories, the battery of tests and things like that, so that we have a good scientific statement about how they are, how they've been affected by the abuse. So in number 6, model declarations, I gave you guys a list of all the different kinds of model declarations. So these are ones we've just redacted that are cases that we already have. If you end up one that so we will try, if you get a new case, we'll say, oh, here's one in the model declaration folder, and also you'll often find when we do a roadmap with you at the very beginning, I'll say, we do a case just like that, so you should look in so-and-so's case and look at theirs. And those are often the ones that I then redact and pull over into this. But peruse this at your leisure. It's super depressing, starting off with a 13-year-old raped by uncle. We sometimes have clients who are now adults but who were sexually abused as children. And so the declaration that is here can be, I've used this as a model for other ones, and it's really helped people not feel like they have to swim back there, and that we can get only the details that are relevant to this. So that declaration is pretty helpful. In addition, sometimes, in addition to having the main victim, the direct victim, sometimes we have indirect victims. So again, with a child sexual abuse where the child was a U.S. citizen and was a child, the indirect victim can be the parent who was helpful and suffered substantial abuse themselves, but they stand in as the victim in those circumstances because they are permitted to be the indirect victim by both state law and by immigration law. So these are some model indirect victim ones. It's where they're going to have to say, I suffered substantial abuse, but in a way that it doesn't take away from the substantial abuse suffered by the child, because we don't want it to be like, oh, it's all about me, my child was sexually abused and I'm so sad. So you do need to not overdo that, but they still need to show that they've suffered substantial abuse. And the indirect victim of a murder victim is obviously the strongest type of indirect victim, because the direct victim is obviously not able to apply. So those are those resources. So that's it for the main presentation. Do you guys have questions?
I have one about the